Hi, and welcome back to Sisterhood in Surgery, April edition. I hope everybody enjoyed the solar eclipse today. It was cloudy in Houston, so we didn't see much. But today's topic is scalpels and suits, navigating malpractice in surgery. And, you know, Palma and I find this to be a very interesting and essential topic for all practicing surgeons because, no matter what, at some point we'll be there. And we have a wonderful panel today of experts on this topic. Remember, this show is live, and so you can either join by the web, go to pollev.com, text your question to DeBakey, or join by text by texting DeBakey to 37607, and texting your question. We'll get those answers live from our experts. And Palma, do you want to start with the introductions?
Yeah, absolutely. It's great to be here today. I'd like to introduce Dr. Dan Clare, who received his medical degree from the University of Virginia School of Medicine. He completed his internship, surgical residency, and vascular fellowship at the Brigham and Women's Hospital, and then a fellowship in the clinical oncology with the American Cancer Society. He served in the U.S. Air Force as chief of the Division of Vascular Surgery at the Andrews Air Force Base before beginning his civilian practice at the Cleveland Clinic Foundation. He was named the division chief of vascular surgery at the New York Presbyterian Hospital, Presbyterian campus in New York City, later returning to the Cleveland Clinic as the department chair of vascular surgery, a position which he held for 10 years. He was then named professor and chair of the Department of Surgery at the University of South Carolina, where he spent 5 years, and then recently came back and was named the inaugural chair and professor of the Department of Vascular Surgery at Vanderbilt, specializing in innovative vascular disease care. Welcome, Dan.
Thank you. Thanks, Palma.
Our next guest
Great to be here.
Dr. O. William Brown, who graduated from the University of Michigan with a BA in philosophy. He completed medical school at Wayne State University, School of Medicine, and a surgical internship at Yale. He completed his general surgery residency at Medical College of Ohio and was one of the first 2 vascular surgery fellows at the Mayo Clinic in Rochester. He is a graduate of the Detroit College of Law and is a member of the State Bar of Michigan. He is a professor of surgery at Oakland University William Beaumont School of Medicine and an adjunct professor of law at Michigan State University College of Law. Dr. Brown is the regional director of vascular surgery for Cornwall East. He is presently the vascular surgery program director and chief of the section at William Beaumont University Hospital. He's been past president of SCVS and has served as an officer or board member in many other vascular societies, including the Michigan Vascular Society, the Midwestern Vascular Surgical Society, and the Society for Vascular Surgery. Welcome, Bill.
Thank you very much. I'm glad to be here.
And last but not least, our attorney, who's our expert today as well, Mr. Martino, started his legal career defending civil litigation claims at the law firm of Smith, Clark, DeLeese, Beerley, Mueller, and Kadick in Tampa, Florida. He then joined Clark and Martino, where he became a partner and advocated solely for plaintiffs, primarily in injury matters and insurance coverage disputes, before joining Older, Lundy, Koch, and Martino. Mr. Martino has tried cases to juries in both the state and federal courts and has extensive experience in representing plaintiffs suffering major injuries in motor vehicle accidents, wrongful deaths, and product liability cases. Mr. Martino currently serves as an officer of the Board of Directors for the Hillsborough County Bar Association and is the president-elect of the same association. He serves as an officer for the Tampa Bay Trial Lawyers Association and was appointed by the Chief Judge of the 13th Judicial Circuit to chair the professionalism panel for Hillsborough County. He's the past president of the HCBA's Young Lawyers Division and the past chair of the Florida's Bar 13th Judicial Circuit Grievance Committee. He's been named to Super Lawyers since 2013 and Best Lawyers since 2015. He's a Martindale Hubbell AV preeminent rated lawyer and has been named by Florida Trend as Legal Elite. Mr. Martino is a member of the Florida Bar, American Bar Association, the American Association of Justice, the Florida Justice Association, Tampa Bay Trial Lawyers Association, and the Tampa Bay Hispanic Association and Hillsborough County Bar Association's Trial and Litigation section. I don't know how you have time to do all that, but welcome.
Well, thank you for having me. It's a pleasure to be with you all.
So it's been said that there are only two things that are certain in life, and that is death and taxes. But Bill Brown recently said that there's a third certainty, and that is if a physician practices medicine long enough in the U.S., he or she will be named in a medical malpractice suit. So that unfortunately is true, kind of sad, but that's why we have this show today, so that we as surgeons, physicians, know what to expect if and when that happens, and are prepared. Palma, you want to start with the first question?
Right. Well, so we know that medical malpractice occurs when a healthcare professional deviates from the standards of their profession, leading to patient harm. So I think what's important, and we'd like to start with today, is to really understand, when does this physician-patient relationship actually start, and what should we be aware of when we do initiate that relationship? Dan, do you want to comment about that?
Sure. So I think the relationship can start at a number of different points. You have patients who contact you or your organization to try and find out if they can receive care from you or your team. So it happens either with the initial contact, or I think probably when you see them in the office and agree to have them as a patient. But I will say, the critical issue with this happens with patients with whom you have a great relationship with, as well as patients you may have had a very difficult or challenging relationship with.
Yeah, physician-patient relationships can develop, unfortunately, all kinds of ways. We see patients in the office, as Dan said, and that's obviously the most obvious way. We see them as consults, and you got a physician-patient relationship there. If you're at home and you get a call on the phone from the emergency room and they tell you about a patient and you decide not to go in and see that patient, you say, well, okay, I'll see it in the morning, and something goes bad, you still have a physician-patient relationship there. So I think there are all kinds of ways. We all know that when we see a patient, we have one, but there are a lot of other ways that you can develop them that you don't think you have one. There's the classic story of a another consult at a private party. Somebody, this is an actual case where somebody said, I've had some pain in my leg. You think it's anything? He says, I've had it for 3 months. And, the doctor said, nah, I think it's okay. It's probably all right. Patient went home and had a PE. And they ended up suing that guy. He just made a comment in a party. So I think you have to be careful that this relationship can develop when you don't think it's developing.
I have a question on that. A lot of times we'll get calls from the transfer center, from the ER doctor, and they're asking what to do, but not necessarily send that patient over. I mean, how does that work? Because you're not really, you're not there to assess the patient. And there's been a couple times when my name has been used, like, talk to Dr. Lay, and I'm like, well, I never talked to them, so how does that work in terms of the patient-physician relationship?
Well, I mean, I would answer that this is really what we call a sidewalk consult. And a sidewalk consult is, as you say, it happens to us all. We're walking down the hall and somebody says, I got this patient who has this. What would you do? Well, I guess I would do this, this, and this. They promptly go down to the chart and write down, thoroughly discussed with Dr. Brown or Dr. Claire, chairman of the department, and he says to do this. And then things go sideways and you go, wait a minute. I never saw this guy. What are you doing here? So I think that's really a sidewalk consult. And you really have no liability because, as we've outlined, you don't have a physician-patient relationship with that patient.
Anthony,
if you walk in and you put your hands on them, now you own them.
And so, Doc, I would respectfully disagree that the law is going to alleviate you from the responsibility.
We're going to have a fight now. Good.
Of course, we got lawyers on the show, right?
Not a fight. Remember, my job, I defend doctors, right? And I'm married to one, a surgeon. So I always tell her, in that phone call, right? So she's an ophthalmologist, and the ER doctor is asking her questions, and her response always is, I cannot assess them from here. I'm not doing the examination. I haven't looked in the eyes. I can't tell you what to do. Because if she undertakes the obligation, or she offers some sort of opinion on the proper course or treatment of what she thinks it probably is, but she hasn't been able to verify, then she's going to be held liable for the consequences if and when that's wrong.
No, we agree on that. I mean, I absolutely, that's what I said. But if another physician asks you about a patient that he's taking care of and says to you, hey, I got this guy on the 3rd floor, I'm doing this, what do you think? And I give him an opinion, then I think the law is pretty clear that that's a sidewalk consult. I haven't seen that patient, and I have not accepted them as a patient. So I would argue you don't have a physician-patient relationship. And I think case law supports that, at least in Michigan. That's
not in Florida.
Michigan, it bails out.
I would say that's an important point for all of us to know, is that states differ in the way that they look at these things. And honestly, even the way that we're consulted, right? Because you get that consult bill and that sidewalk consult, and you know that patient's, maybe you know that patient's medical record number, and you look at the CT scan, you know, you've got an eye on the CT scan, and now all of a sudden, does that make you liable because you've looked at the CT scan? You've never seen the patient, but you've said, no, this doesn't look like a ruptured aneurysm, or this doesn't look like a whatever.
Yeah, I think once you see that CT scan, you now own them.
Okay.
Yeah, I would argue you own them.
Yeah. And I wonder for some of the technologies that are being utilized right now. So your wife is an ophthalmologist, but if they have retinal images that she's able to view, and they ask her, hey, can you look at this retinal image? Because those are things that are going to be available to us now at home. And once you start doing that, I think,
I think you've undertaken a portion of the care, and then are going to ultimately be held to have interpreted it correctly.
Once you've looked at those pictures, I absolutely agree. You own them. Your fingerprints are on them.
Yeah.
But a lot of times we get a call from the transfer center, or I get called by a local ER saying, I have a caffeine DVT. I'm going to put them on Xarelto. Would you be willing to see this patient and follow up at the office? So that's not really a relationship, right? And they're not asking me to come see the patient and confirm.
That's a little bit different, because now they've basically asked you to consult on this patient. Now, you haven't seen the patient, and that sort of makes it a little difficult in terms of, now you start to walk, what I love about the law, now you start to walk on that gray line again, and it just sort of depends on which the judge thinks, what the jury thinks, and things like that. That's why, as physicians, we have such a tough time about that. It's not like the creatinine is this. It doesn't change. This is the creatinine. It's, well, I think that this might be, well, I don't know, I would say. So you're right. It can become cloudy.
But wouldn't it be on that ER physicians, like they're the ones that made the decision that the patient can go home with the oral, anticoagulation. They just are getting an outpatient follow. Like, I don't know how, I guess if somebody's suing, they would sue the whole kit and caboodle, I guess. I don't know. Because as the receiving end, like if I was Palma, I'd be like, well, I didn't make the decision to send that patient home. I just got called for outpatient follow-up.
Yeah, you're exactly right. That's what I would do too. But what they're doing is you have to understand that your colleagues, and they are your colleagues, are basically diffusing the heat. They're saying, I'm going to make this decision, but you know what? Let's bring everybody into the crowd here. Let's give everybody a little action here. So they sort of want to diffuse the heat a little bit. Yeah. So if things go wrong, they go, yeah, but I talked to Dr. Lee, and she's an expert. And so you got to be careful of that. And you got to be, if you don't have a chart, you can't document anything. You say, listen, you want to send them to me, send them to me. But I'm not accepting their care. I think that's, again, it all comes down to documentation, as it always does in medical legal stuff.
Anthony, did you have a comment?
Yeah, I think once you weigh in, so the concept that we're talking about under the law is called a duty, right? And at what point do you undertake a duty of care to that patient? And I would argue, at least under Florida law, once you weigh in any capacity on their care, treatment, diagnoses, that you're going to be held responsible for whether or not what you ultimately recommended was appropriate and accurate under the circumstances, which of course is severely complicated when it's done over the phone. And as Dr. Brown alluded to, it's generally going to be it's someone calling you who is not a specialist in your particular field, and they're going to say they relied on you for your expertise in that particular field in weighing in on that component of the care. And if it's wrong, I think you're ultimately going to be held responsible for that.
You know what else happens in the transfer? I'm in a more rural environment, right? So in the transfer center, they call you. That whole conversation is taped. Can you talk to Dr. Jones at this certain hospital that's 3 hours away? We have no beds, but they just want to talk to you about the patient. If you think it's truly urgent, they'll have to look for somewhere else to send the patient if we're on diversion. Or can you decide if that patient can wait till there's a bed, which could be a day, it could be 3 days. I mean, this is like a very common thing in my practice.
Very common. Oh, yes.
For you guys said that too,
Yeah.
right?
Every practice.
Okay.
Yeah.
But the good news is, Palma, is that you realize that it's being recorded. So you can lay the record and foundation. You can set the whole record straight. Because a lot of people forget it's recorded. Okay? And unfortunately, the language they use, aside from the content they use, is, unfortunate. But as long as you remember that, hey, I'm laying the foundation. So just lay the record and make it clear. Again, that's the documentation. If you're saying, yes, I would do this, but I'm not seeing the patient, I want to be clear that I'm not making a diagnosis. Again, it's documentation.
Like we'd be
You got
happy
to say at 2 a.m, Bill. I'm not thinking like that. And the other thing that happens with this too is the ER PA or nurse practitioner is calling you because the radiologist called them about their interpretation of an ultrasound. So you have almost a third-hand description of what's going on, and you're offering an opinion about this. And it is often 1 or 2 in the morning when this kind of thing happens. My first question is, why is this person in your emergency room at 2 o'clock in the morning? Because a lot of these things seem benign, but that's actually when you need to be perhaps most on your game. Because why is a person with a cap vein DVT in an emergency room at 2 a.m?
They might have been sitting there since 2 p.m.
They might have been. You're absolutely right.
I have no idea how long they've been sitting there.
But they came. I think Dan's point's really well, but they came. Why are they there? At 2 o'clock in the afternoon even. What made you come today? You didn't get this 3 minutes ago. What brought you there now? And I think that's critical.
Again, that's also something that you often don't have information about. You're getting something, and at 1 a.m, it's often somebody who has just been signed over from the physician who left at midnight. And the ER PA may be calling you and saying, I've never seen this patient, but the person who signed out to me told me that the ultrasound showed this from the radiologist who's not available to look at this, and you can't see the image. I mean, that's literally what we're dealing with. And clearly
I would advise you not to do that.
What do you say, Anthony? What do you say to these people? Because then, you're not, your administration or my chief would say, you should be taking these patients. You should be accepting all calls, be, customer friendly,
It's the rock and the hard pace, right? And it's also, you're fighting the empathy where you want to help, right? And so you're trying to help in any way that you can. The problem would be, or I guess the ultimate criticism would be that you didn't have all of the relevant information to make those decisions, right? So if any of you have had the unfortunate experience of having your deposition taken, right? Sometimes you're asked a particular question, but you don't have the requisite predicate to answer it. You're going to say, well, what were the labs? What was the imaging? How'd they present? What is the history? And what we're talking about is the fact that you're in that scenario, you don't have all of that. And you're also relying upon a person who's probably not qualified to interpret that image, and they're telling you what they think it shows or what someone else told them it showed, right? Mm-hmm. And so if you're willing to rely on bad information and then make it render an opinion or dictate the care and course of treatment, to the extent it's wrong, then I think you're going to ultimately be held accountable for it. And that's the difficulty in this. And so if you feel so compelled, then you'd have to get up and go, unfortunately, or make sure there's somebody else adequately qualified at the hospital or whatever facility they're at to come in and actually examine them.
Well, there was a scenario where someone proposed that at our vascular lab, we own the lab, they're doing ultrasounds for outpatient, and they find, let's say, a calf vein or popliteal vein DVT. And it was proposed, not by me, that we receive a call from the tech, and would we be willing to prescribe the anticoagulant for that patient, who I've never met, I've not seen. I don't have a clinic appointment to see that patient because in that building, I don't see patients. Yet, would I be willing to prescribe anticoagulation for that patient and then follow them up in my office? So I was like, I don't think so. I mean, because I'm not seeing this patient, I'm treating an ultrasound. What if they have a complication related to the anticoagulation? What if they don't follow up and say, oh, well, you never gave me an appointment, or I never, or I didn't understand, or what if there was a misdiagnosis? I mean, I felt like I didn't think that was a prudent thing to do.
100% right. That's a firm no. That's a firm no. I'm not.
That would be no. Okay.
That would be no. I'm not doing that. One of the things I do want to bring up, though, and I usually when I do talk about this, is that I think that everybody needs to understand. You get consulted, and they're at another hospital, et cetera, and they say, well, I don't have any liability because I didn't charge the patient. I never sent a bill. I didn't charge the patient. And it's important to remember that charging has nothing to do with this at all. Okay, it has no impact at all whether you charge them. So what I tell everybody is charge everybody. You're getting sued anyway. So anybody you see, charge them because you're getting sued anyway.
So optimistic, Bill. Yeah. That's great.
Well, that's true. Never work for free.
Yeah. No, you're right.
So moving on in terms of, so say we get named in a malpractice suit. So what happens then? I mean, for me, I work for a big organization, so I assume, it hasn't happened yet, but I assume I go to my legal department, and then they would sort of help, me along in terms of what I need to do. But what would be those steps, just so that the audience understands what it would look like?
So most large facilities like that have a legal counsel, or I forget the official term for it. But what you can do is take the letter that you've gotten, and usually even before that, you'll get a letter that states that they're requesting records, and really what they're doing is they're preserving the right to potentially bring legal action down the road. And Bill and Anthony, you can probably answer this better, but as a physician, my move is immediately to legal counsel of the organization or legal counsel for the group to say, hey, I've gotten this. Can you help me with the steps from here?
Yeah, Dr. Claire is 100% right. And for those in private practice, it's usually going to be your insurance company. And you're going to hand it over to them. They're going to process it. They're going to appoint legal counsel to defend you pursuant to their obligations under the insurance. In Florida, we have a pretty robust pre-suit procedure, and Dr. Claire, you're correct. The first thing that comes is a request for records, right? And if you don't produce the records within 10 days, you're going to waive pre-suit affidavits. It has other implications. But if you get any type of communication from a lawyer relating to the treatment and care of your patient, immediately turn it over to legal or give it to your insurance company. And it may be that you're just being brought in potentially as a subsequent treating physician. What most people don't realize is that their insurance company, your professional liability malpractice insurance, will actually provide you a lawyer who will prep you, defend you through a deposition just as a treating physician, where you're not even a target, and that ensures that you don't go afield and offer any criticisms of any other of the respective physicians, and you confine to your care and treatment of the patient, and it'll make the procedure a lot easier for you, because I know many physicians, they end up hiring me to come in and do that for them, there's anxiety associated with it, right? And so I think putting it in the hands of people who do this for a living is going to give you a lot more comfort and answers as you navigate through that process.
Anything to add, Bill?
Yeah, no, I you're exactly right. You described it. In Michigan, it's called an NOI, or a notice of intent. I affectionately refer to that as a stick-up letter, basically telling you, pay me some money, I'm going to sue you. And so, you know, it was set up. It was originally set up back in the day. What used to happen was process servers would walk into your clinic day and say, here, I'm here from the lawyer. I'm suing Dr. Brown. Is he here? I need to give him this complaint. And so they finally got away from that. And they said, well, you know, we really don't need to do that. So they give you this notice of intent that says, you know, if you don't pay us money, we're going to file a claim against you. And they thought that this would help mediate some claims. It never really did. Basically, defense attorneys, and you can comment on this, don't need to lie, but defense attorneys pay no attention to the notice of intent. They say, okay, fine, we're not doing anything about this. And then you have to wait. The notice of intent in Michigan, I think, is 180 days. So they cannot file suit until 180 days passes. And then after that, or if you don't answer the notice of intent, it's 154 days. And so then they can file a complaint. But until then, there's no complaint. And in fact, what's important to remember is for everybody looking, if you get a notice of intent, that doesn't mean that they've even had a doctor look at that. They don't have to have a physician look at the case to file a notice of intent. What they're basically doing, as Tony talked about before, is they're staying the statute. They're basically saying, you know what, I need some more time to sort this out. I'm just going to send this letter that says, you know what, here, we're going to sue you. And so I think that if you get a notice of intent, you have not been sued, but you certainly need to follow all the same steps that have been outlined by Dan and by Tony. You know, get it to your insurance carrier, get it to your attorney, and move it along as if you were sued.
Yeah, in Florida, it's a little different because then it invokes a pre-suit procedure discovery process. You can take unsworn statements, but it also would require a claimant or a plaintiff to have affidavits from similarly trained specialists where they attest to a deviation from the standard of care. Then the defendant has an opportunity to admit liability and move this into an arbitration proceeding, or they can deny it, at which point then you've complied with all the pre-suit requirements and then can file a lawsuit. But you cannot until all of those steps are adhered to.
So this leads into standard of care. I mean, is that a rigid definition, or I mean, how does that get interpreted, and does it vary state to state, or it's like, you know, vascular surgery is different than orthopedic surgery or psychology?
Okay, yeah, standard of care, at least in Florida, requires expert testimony as to the prevailing professional standard of care for that healthcare provider. So it's going to be specialty specific, okay? And so basically what they say, the definition legally would be the level of care, skill, and treatment, which in light of all relevant surrounding circumstances is recognized as acceptable and appropriate by reasonably prudent similar healthcare providers.
So I mean, it's a perfect situation, but given the scenario or the circumstances, that was the best possible outcome that most people would expect.
Well, I was just going to go, for us, people in Michigan are not quite as smart as the guys in Florida. We just say it's what the ordinary physician would do under like or similar circumstances. That's the cliff notes for us. And as a physician, that's really what you need to say, is what somebody asks you, doctor, are you familiar with the standard of care? Yes, it's what the ordinary physician would do. Now they say ordinary prudent. Well, it seems sort of silly. It was the ordinary unprudent physician would, I mean, that's sort of a ridiculous thing to say. So it's what the ordinary physician would do under like or similar circumstances. But as you suggested, Paul, it's not the best care possible. Okay, it's not the best possible care that's available. Is what the ordinary physician would do.
I guess I want to talk a little bit about consent. You know, it comes up from time to time that we have to get an outside consenter, like someone that's a healthcare proxy, or even in trauma victims or emergency situations, we have to take like a two-phone consent. I mean, what are the pitfalls of that scenario?
Well, informed consent is specifically defined in Florida. We actually have a jury instruction on this. It requires information sufficient to give a reasonable person a general understanding of the proposed treatment or procedure, of any medically acceptable alternative treatments or procedures, and the substantial risks and hazards inherent within that treatment.
So it doesn't have to be every possible esoteric thing that could potentially happen.
No, I don't think it does. The jury instruction talks about substantial risks or hazards that are inherent, right? So if your incident rate is 1 in a million, no, I don't think that needs to be in there. But if anything is occurring with sufficient prevalence, then certainly that would be something that you'd want to discuss with the patient.
Now, it's important to differentiate, Palma, the difference between informed consent and consent form. They're two totally different things. Informed consent is what we get from patients. We explain to them what we're going to do, what the risks and benefits, et cetera, et cetera. That's not the same as the consent form you get as you're wheeling them into the operating room, to say, I'm going to do this, this, and this. Sign right here. Okay? If you get that, that's not informed consent. That's a consent form. But the difference is crucial, because a consent form, that one you get before you get, protects you against civil and criminal battery. Okay? Which is very important. One, criminal, because you don't want to end up in jail for something you did. And I was in a case where they sued the physician for criminal battery. And two, civil battery, which is money. But the problem is your malpractice insurance doesn't pay for civil battery. It pays for malpractice. So you could get a judgment against you for $200,000, $300,000 and say, well, okay, I got $1 million coverage. Now you don't. Okay? You have $1 million coverage for malpractice, but not for civil battery. So you need to keep those things, separate in your mind. And there are two components to it.
And when you talk about civil battery, you talk about like a patient sues you because they said you physically
assaulted them.
Yeah. Wow.
Okay. Not assaulted. Assaulted is if you warn them. If you say, I'm not going to do this to you. Now you hit them. Now you got assault and battery. Okay.
You gave them informed consent, but they didn't sign the consent form. So now that is assault and battery.
Well, it is. It's assault. That's clearly assault and battery.
Oh my
That's the case I would certainly make there. But I think that, in terms of the battery is an unwanted touching. Is basically, again, sort of break it down to the Cliff Notes, and Tony, correct me if I'm wrong, but
yeah, I was going to say harmful or offensive contact on the person of another, right?
Yeah. If you don't have something that says you can do that to you, they got you.
Okay, so we're in an emergency.
Here, let me give a scenario, Doc. Right? I probably can't come up with a specific procedure that this would work, but while in the procedure, you discover some other underlying condition, and you decide to effectuate a repair at that point in time. But it has some sort of collateral limitation that's going to come from it. And the patient was not aware that this was a possibility while you were in there, right? You might see this sometimes in spinal surgeries or the like, and they discover...
So we're doing an aneurysm repair, and we find the appendix is inflamed. Mm-hmm. So we remove the appendix, and we don't touch the aneurysm.
Correct. Now, granted, to make it really a viable cause, there would have to be some other damage or impact to the patient resulting from the removal, right? That's the damages component. And at some point, I'm sure we'll discuss about what are the different elements of actual legal malpractice, because we've touched on the duty. Now we're touching on breaches of care, and then you've got to have a causally related harm from it. Otherwise, it's kind of a no harm, no foul. But in this scenario, that's exactly right. That would be what Dr. Brown was discussing as what could theoretically constitute a battery, as odd as it sounds in this context.
Usually, if I'm not mistaken, in most hospitals I've ever worked in, I don't know, Dan, you can sort of speak to this, Linda and Palma, there's usually this disclaimer, this catch-all that says, we're going to do this procedure and any other thing that we happen to have that we run into, we're going to do this, okay?
That's right. You need a haircut too, so we're going to do that.
Right, we're going to do this, but if we see something else we want to do, we're going to do that too, and you think that's okay also.
Yeah.
And so, that's one of the things that is in there to protect you. The other thing I think in that kind of situation is that if you were, you try to put yourself in the position of a juror, the juror sitting there goes, okay, I got this ruptured appendix. I would want my doctor to do that. So I think it's, yes, legally you could be, you could make the case the other way, but I think you're sitting on pretty solid ground there in that kind of a situation.
Okay, so let me ask another question. So we've all been in this situation. There's a patient in the emergency room with a ruptured aneurysm. There's no family. There's no easy way to contact them. They're hypotensive and they need emergent surgery. And they're not with it enough to give us consent. Now, in those situations, what I've usually done is document in the chart, this is an emergency. We cannot contact family. And so we're going to take this patient to the operating room emergently to fix this aneurysm.
I don't think anybody would give you a hard time about that. I shouldn't say that. I've seen a lot of funny stuff, so I won't say anybody, but I suspect that would be very, very, very unlikely in that kind of situation, because you'd have to sell, a plaintiff attorney would have to sell the jury that that you should let the guy die, that you shouldn't. And that's a tough sell. Tony, you got a plaintiff attorney, that'd be a tough sell, wouldn't it?
Yeah, that's a non-starter. The reality is that, at least in Florida, malpractice suits constitute less than 0.5% of all civil filings. Okay. And the physicians prevail about, it's like 85-90% if they ever get to trial. And it's because of things like that. Jury is not going to criticize a physician who intervenes trying to help or save a patient. They're not. That's not a winning case. That's not a winning argument. In my experience, the only ones that really have any teeth to them are, a flat misdiagnosis where all the signs and symptoms were there, or a refusal to intervene, right? The on-call physician was out at dinner and he didn't feel like coming in, told them to hold over the patient till the next morning, and they cascade overnight, right? But trying to intervene and doc, as you were pointing out, you document the necessity, the reasons, and the inability to consent anyone else or what have you, and the urgency of the situation takes over. And I don't think anyone's going to criticize you for that.
So
I'll tell you a funny story about consent real quick. I got called in for a ruptured aneurysm. It's a young guy. He had to take him to the operating room. He really didn't want surgery, but I said, this is ruptured. You're going to die. And he said, okay, all right, fine. You got to take me. I got him to the operating room. They were putting him to sleep back in the day with pentothal. And the last words out of his mouth were, I feel better. Don't do it. Those were the last words out of his mouth that he was going to sleep. I feel better. Don't do it. Now, needless to say, we went on, but it gave everybody a little pause to hear him say that.
That is funny. With big corporations, do they usually settle in arbitration? What are the trends? Is it unlikely to actually get to court if you are named in a malpractice suit? Define what court is, right? So getting into litigation where there's a judge and there are formal processes where there's subpoenas being issued and depositions occurring, if you're named, you're going to at least participate in a portion of that. Typically what happens is throughout that process, they begin ferreting out
who may actually have responsibility and liability. And so the big net that's thrown initially, bringing in basically everyone who touched the patient, they start releasing those entities and they start focusing on the actors who they think bear responsibility. If the evidence is clear, where you've got a deviation in the standard of care, whether it's a clear miss or a failure to intervene, those cases are going to settle. Typically, the ones that actually proceed to trial, like I said, overwhelmingly are resolved in favor of the physician. Now, of course, that's the least desirable outcome because the physician is then stuck in that process for years, potentially, but ultimately get vindicated, at the end.
Well, I have to, wait a minute, I have to argue with vindicated. And the reason I argue with vindicated is because the problem is that basically it suggests that if you don't go to trial and you settle a case, that you're not vindicated. And I think that it's important for physicians to remember that this is a business decision. And I suspect you'll agree with that more than anybody. This is a business decision. So you don't want to get into a situation where you say, you know what, I'm going to clear my name. I'm going to trial. I'm going to take this till the ends of the earth. Sometimes, if you can settle it for a reasonable amount, you settle a case and you walk away. It's the price of doing business. And that's the thing we have the hardest time doing. We think that, well, if we say that we're settling it, well, we admit guilt. You are not admitting guilt. All you're saying is, I don't want to talk about it anymore. And then that's the end of it.
Doc, I could not agree with you more.
But there's a lot of emotion here. Like I hear the emotion even from both of you, and I think Dan has some thoughts about this as well. I mean, there's a lot of emotions going through this process. Is it stress? Is it depression? Is it anxiety? You're probably all over the place, really, right? And you feel very violated. They're digging into every aspect, and they're challenging that you're a good doctor, and that they're saying you're not a good doctor, and then you're starting to feel, maybe question yourself. Any thoughts on that, or?
Yeah, so we haven't talked about this, but once you get once you're named in the suit, boy, I got to tell you, even that request for records that you get, at least in my experience, it is demoralizing and you question what you're doing and should I be doing this and should I be continuing to do this and the lawyers I've worked with have been very helpful in helping physicians come to terms with that, but it is a very emotional thing too. And you don't want to, there is this sense, Bill, that you're settling is the last thing you're going to do because you were right in what you did. But I also have to admit, this permeates every part of your practice and your life outside your practice as well, because it affects your relationship with your family members because you're constantly stressed about this. Now, I wouldn't say every day you're thinking about it, but every day you get mentioned about something relating to this, it is draining, emotionally draining on you. And we haven't talked about this, but the part that comes next is really you, giving a deposition, and that probably would be a very good thing to cover in this venue.
Well, let's cover that because we only have 15 more minutes. And I want to comment. I think when you get these letters, it's questioning your identity too, right? Because our job, our career is so much part of us that yeah, you're right. It's demoralizing. It's questioning our identity. It's sort of what am I doing? Am I, this whole time, am I a fraud? So I could totally see that. But yeah, so deposition.
Yeah, providing some guidance on how to prepare for a deposition would probably be helpful, since if you're in any lawsuit, even if you're peripherally engaged in a lawsuit, they're gonna ask you to give a deposition.
I guess this one comes to me. But Dr. Claire and Dr. Brown, I agree with you. You have to do your best to disassociate with the process, with all of the emotions and the anger and everything that's going to come with someone potentially challenging whether your skills or your care. and give it to the insurance company so they get lawyers involved who are going to be, they should be more objective on it, right? And at the end of the day, yeah, it's a business decision in the sense that you don't want to be personally exposed where you are writing a check. It's the insurance company's money, so if they can make it go away, make it go away. You don't want to be an obstacle to that because you want this to end. As far as preparing for a deposition, like I said earlier, even if you're being roped into some sort of litigation as a treating physician, your professional liability carrier, or if you're in a big hospital system or a university, they're going to have an in-house legal department who is going to help prepare you for these things. The thing you're going to want to do is reread your records, right, and be familiar with them. Now, granted, during a deposition, you'll have your chart accessible to you, but I would always caution people, right, we're not going to step outside of the confines of that, and we're going to be very careful if I even allow you to answer a hypothetical, right, because that's where they're going to ultimately want to go with this. But just knowing your particular chart as it pertains to this patient, you're going to know more on the subject matter than whatever lawyer is asking you questions. So you can take some comfort in that. And then you only answer predicated on sound medicine, sound science, or the particular treatment you rendered. And this goes back to something Dr. Brown was talking about earlier. The better you document your file, the better you're going to be prepared in a situation where somebody wants to take your deposition, right? Particularly non-compliance of patients, things of that nature. You want to make sure all of that stuff is in there, because if you get called to a deposition 3 years post, you're not going to have an independent recollection of that. But you're going to be able to look back at your chart and say, they didn't do this, they weren't taking their medicine, they weren't whatever it was. And then that's the compounding comparative negligence of the plaintiff in producing their own, adverse result.
So I guess, Dan, what I would say in terms of preparing for a deposition, and certainly I agree with everything you just said, but what I would say is I sort of have talked about this, and basically in preparing for a deposition, the first thing, the major thing that you have to understand, you want to answer only the questions that are asked, okay? And you want to answer specific questions. You don't want to embellish. Plaintiff attorneys, again, with all due respect, plaintiff attorneys say, so what do you think happened here? You don't want to answer that question. What you want to say is, I'll be happy to answer any specific question. I guess I don't know what you mean by what happened here. The other thing is, the other classic mistake is that, let me just, 1 second. Okay, so the other classic mistake is that physicians think that, if I just explain this to this plaintiff attorney and tell him exactly, he's going to go, oh, that's what happened. Oh, I'm going to drop this now. Thanks for explaining it to me. I guess I just didn't really know what was going on. But now that you explained it to me, you don't want to do that. He's never, or she's never going to do that. So you just want to answer specific questions. The other thing they will do is some attorneys, we won't say all, but some attorneys will try to annoy you. They want to see what kind of a witness you're going to be. So they will say things to particularly annoy you and to see, are you going to lose your temper? Are you going to get upset? And if you do, they win. If you get angry at them, they win. So what you really have to do is sit there and just answer questions. And I think one of the most important things that Tony said was, no matter how much they read, no matter how many experts they talk to, they can never know as much vascular surgery as you do. Okay? It's impossible. And so that's your overwhelming advantage. They can never know what you know. And so again, I would certainly agree with that.
I would say the other thing I've heard from a couple of people during the depositions too, or from legal counsel I've been working with, is don't educate the other lawyer. So answer their questions, but don't provide them with a background on, a description of all of the different possibilities that could happen or all of the different options. Just answer what you did in this scenario. And
don't give them literature. Make them do their own homework.
Nothing's authoritative.
Nothing is authoritative is exactly right. The other thing I would just say along those lines, a plaintiff's attorney not uncommonly will read you something. Doctor, do you agree with this, and they'll read a sentence out of somewhere, but they'll pick that sentence out of the middle of a paragraph. Don't ever answer. And again, my advice as you know, a physician who's been through this and as an attorney, don't ever answer until you say to them, may I see that article? May I see where you're quoting from? Okay, now they may take it to the judge and say, I don't have to. I can use it for this reason or that reason. I've seen, but you don't want to comment on an isolated sentence. You want to know where it's coming from.
So I was an expert witness in a case where the counsel asked me about something that was on the website of the organization that I worked for related to vascular disease. And I asked him, can I see that? Because I don't know what this is in the midst of. And he said, I'm not going to provide this. You can get this from your counsel. So the lawyer I was working with actually had to bring it up on the website and, read it to me. And then I actually was able to say, well, you've taken this completely out of context. It was really bad for the lawyer who was trying to get me to say something. But I mean, that, I didn't even understand that I could do that initially, because I was but I mean, I think it's important to know that what you said, that if you hear something, you can ask to see, can I see where that's from? Can you show me that? I
had a similar experience with a lawyer quoted something. I said, I need to see the article. He said, well, I'm not going to show it to you. I'm allowed to quote this. I said, okay, can you tell me when it was published, or is that a secret too? And that was the end of that question. That was the end of that.
So we have a question from the audience, and we only have a few minutes left, and we didn't even get to cover everything we wanted to cover. What is the biggest legal challenge in clinical trials? I guess that question means if a patient is in a clinical trial, something goes wrong.
That's great, because that's not standard of care, right? That's now an investigational trial. And
that's going to be an informed consent issue.
Yeah.
Okay.
So they have to fully appreciate whatever risk it is that they're going to undertake to participate in that.
Okay.
So I would argue that when we're doing a lot of these trials, though, you don't necessarily, so we're delivering an agent that's never been used in extensively in this disease process before, or we're doing a procedure that has not been done extensively. And so a complete understanding of the risks is unrealistic.
Well, and so I think it's a complete understanding of the fact that there are these unknown risks.
Yeah.
As opposed to identifying, because obviously you're not going to know what the determinative risks are of experimental procedures. That's what you're discovering through that process. But I think it's knowledge, the patient's understanding of the fact that you don't know, right? And you just give them their best estimations of what you think might occur.
And then quickly, can we go over caps on non-economic losses? Because that's a question a lot of physicians were, but like, can they take my house and home? My house, my home, my car, my money in my bank account.
I think, well, I mean, I'll just speak up briefly. There are certain things, they used to be able to take your pension and profit sharing plan. They can't do that anymore, okay? They can't go after your pension and profit sharing plan. As far as your house, if your house, and again, state of Michigan, if your house property is owned as tenants by the entireties, which means if you're married, you hold it with your wife, it's judgment proof. So they can't take your house. I think that anything else, I guess if you put it in trust, and I leave this up to you, Tony, if you put it in trust, I guess that may be protected. Yeah,
so, Florida's a little different, right? So we have homestead protection on our homes. So your home in Florida would never be subject to a judgment creditor like that. We had caps that were declared unconstitutional. It was originally $500,000 in non-economic damages, and then I think it was $1 million in a death case, and then it was higher for facilities. That was struck down, but there's new legislation to bring that back. Dr. Brown, as you're alluding to, I think any practitioner out there with any type of substantial wealth should consult with an estate planning lawyer, and they specialize in asset protection, because yes, there are a number of different vehicles, not only for tax benefit purposes and ways to pass to either your spouse or your surviving children, but as well to keep them insulated from any types of claims arising from any liability.
But to make everybody a little more comfortable, Tony, the truth is most plaintiff attorneys aren't going to take the time, the effort, or whatever to try to go after your personal assets. They just ain't interested in doing that. I'd like you to speak to that, because everybody's scared to death that they're going to come in their piggy bank and start taking them. And the truth is this, the plaintiff attorney, he wants your insurance, he wants to get out and move on to his next case.
That is true. From a practical, real life scenario, they don't want to chase you, because it presupposes a number of things. One, they're going to have to take the case all the way through a trial. They're going to have to prevail. They're going to have an award which exceeds your available insurance. Then they're going to have to start a new proceeding to collect on that judgment. And now they're going to have to chase you to try to attach different assets for sales and the like, and to satisfy this judgment. Right? And so your individual liabilities, if you own things jointly with your spouse, they can't be divided and sold and forced to pay these things. So in a practical sense, the lawyer is not staying on board and going to chase you personally for whatever the delta was in excess of your insurance.
That's a good point. Well, that makes me feel better. Palma, do you have any
comments? I just wanted to hear, I guess in closing comments, each of our guests kind of, you have a junior partner, or, Anthony, you just meet this young, eager, 1 year out of training a vascular surgeon. What advice would you give them at a cocktail party? Tips, a couple tips.
Is this a sidewalk consult? I'm just kidding.
What's that?
I said, is this a sidewalk consult? No, I'm kidding.
Over drinks.
I don't know. During my wife's residency and fellowship, they had me come speak at grand rounds on these types of things. I think the biggest one is always going to be extra documentation in your chart. You guys get busy in a clinical setting. Sometimes you have too many people in clinic that day, or you have things going on in the hospital. And you may neglect to write down everything of consequence that the patient conveyed to you, or their caregiver did, or what have you. So I think documentation is paramount. And I think communication with the patients is as well. So oftentimes you might have a bad result, which isn't malpractice. But if you are standoffish and you don't address it with them, I think that they've proven psychologically the natural response is then they start to suspect that something may have happened. Yeah. You did something wrong, as opposed to it simply being a bad result. I think the studies show that if you kind of own it, address it with them, and explain it to them, statistically, they are far less likely to ever bring a claim against you.
Great advice.
Bill, Dan?
I would just say, when you have this happen, the one thing that I think is really important is to lean on your support. So, this is where having emotional support through family, friends, and actually other clinicians who've been through this before is incredibly valuable. The lawyer you're working with becomes an emotional resource for you as well, because they have been through this a lot with other physicians before. So, I know from having, been involved in these, it is emotionally draining, and you need a lot of support through this, and it can last for years. It doesn't just go away.
Yeah, and I would agree. The key is the documentation. The document. That's the real key thing. And I would also tell a young colleague, do what you think is right. Don't practice medicine for the lawyers. Practice it for your patient. Do what you think is best for your patient. Yes, you consider the ramifications, but treat your patients like you'd want your family treated. And that's what I would tell.
Well, that's all great advice to end on. This was a wonderful show. Lots to that we learned about. And we want to thank you for your time and your expertise on the topic.
Thank you so much for everything. It was great. We learned a lot. And I think our viewers did as well. Thank you.
Thank you.
Good
Have a
night.
Thanks.